So, Justice Goodwyn, let me ask you perhaps what may seem like a provocative question in light of what we've just heard about, I think, restraint of the courts. Do you think courts function as change agents or should function as change agents in our society?
I think that they do not, and I think that they should not. Our job as judges is primarily to act as umpires and referees. You know, we're calling the balls and strikes, and we're using the Constitution of the United States, the Constitution of Virginia, and the statutes that have been passed by the General Assembly and Congress. So in that role, I don't think we're agents for change. Sometimes it may seem like we're changing things, but what we're doing is making sure that the rules are applied fairly to everyone.
So a very famous umpire once said, balls and strikes ain't nothing till I call them, right?
That's exactly right.
So the court, in some respect, is playing a role in helping to shape what the law is.
No doubt about it, and that's what my colleagues were just explaining as to how we do that. That's certainly part of the process.
Okay. Well, that actually leads me to my next question. Justice Goodwyn, do you think, it sounds like for what the Chief Justice is saying, that the public in general doesn't have the same sort of appreciation for state constitutional law that it does for federal constitutional law. Do you think that's the case?
I don't think so. I think that the reality of the situation is that in most instances, because of the 14th Amendment, your rights under the state constitution are the same as your rights under the federal constitution. So as a practical matter, people don't make the distinction between the two. I don't think it's them not taking it seriously. I think it's them not realizing.
So is there something that you think, to respond to the Chief Justice's, the issue she identified, something more that can be done to better educate the public about the role of the state Supreme Court in their lives?
I don't think that a whole lot can be done other than what the Chief Justice just mentioned. Mm-hmm. It's a matter of civics education. Mm-hmm. And certainly, I think each one of us, probably we each speak regularly to different groups, mm-hmm. and normally a part of that speech is going to be explaining what you do. Mm-hmm. So I guess a little at a time, people certainly are finding out, or they find out, but I don't think it's one of the most important things on their agenda to understand how the Virginia Supreme Court works. Right. So all we can do is educate the people we come into contact with.
Well,
I mean,
please.
I was going to add another point, and the Chief Justice touched on this before. I think most people really don't understand the difference between state court or federal court. I was at a church not too long ago and I was introduced, and when church was out, some little old lady made a beeline to me to give me the devil about the same-sex marriage issue that we were going to be deciding. I was like, I think you got the wrong person. It's not in our court. But she had no idea. She just heard I was on the Supreme Court and the issue was going to the Supreme Court, and she wanted me to hear what she had to say about it.
Justice Goodwyn, let me ask you to address that as well, so that your thought process as you work through the case. So Justice Powell has talked about it being an evolving process. I'm sure that's the same for you as well. But do your thoughts continue to evolve through oral argument, through conference, or do you go into oral argument, into conference with a pretty clear sense of what you think?
I would say typically my process works exactly like Judge Powell's process. But in reality, what I've realized is depending on the subject area of the case, I might have more of an intuitive feel as to how it ought to go. If I know the body of law in a particular area and somebody's asking me to do something that seems completely contrary to the last 4 cases we decided, it's like, they've got a boulder they're pushing up a hill here. And I'm not saying I made up my mind one way or the other. I'm just saying that, all the alarms are going off that, if I've read the appellant's brief, I'm like,
use a term of art, yes.
Yeah, exactly. That was a technical term.
Yes.
So that happens, and I find it happens the more background I have in the information in the particular subject area of the case. But even with that being said, I'm going to read everything, and my mind is completely open. And one of the things that kind of amazed me when I got to this court, because I read everything, and I think everybody's process is probably somewhat the same. You read the briefs, then I'm going to look at the research, typically a bench memo or something like that. And then a lot of times I'll have little questions. As I'm going through the briefs, I make notes like, why did they say that? Well, that don't make any sense. You know, like, and then I go back and kind of answer my own questions to all these things that were left hanging out there. And then I pick up a dictaphone and I do something, I call it my bottom line, that my law clerks go. I just pick up the dictaphone and says, look, you know what the real deal on this case is? You know, and then I just kind of dictate to myself how I think they're trying to tell me and characterize the case in the way that I believe it ought to be characterized given the facts and given what happened at trial and what the important concepts are that have to be dealt with and the questions that have to be dealt with. And that's what I'm going to take into the opinion conference with me as my colleagues talk. That's kind of like my touchstone for how I'm going to analyze things. And typically I try to come up with an answer at the end. But all of that being said, I was shocked to know how many times I have all of that and I get to oral argument and somebody says something like, I never thought of it that way. You know, wow, maybe I mischaracterized what the real issue is. And then you're all ears to try to fill in the blanks. So I mean, I think it is an evolving process, and I think we've all honestly been doing this long enough that you never say never. You know, you're going to read everything and you want to understand the issues, and you're keeping an open enough mind so that when you hear something that doesn't fit into the concept or the construct you've created, you're like, wait a minute, I hadn't thought of that. Where does that fit? Does that make a difference? Whoa. And you know, you see people at oral arguments start sitting up on the edge of their chair like, oh, and sometimes you see people's eyes get really big as they have a revelation during the process.
So now I have to ask what you do with that recording you make. Do you listen to it yourself at conference?
No, I have my secretary type it,
okay.
And it goes into a document I call the bottom line. So I've got, you know, all the cases and everything, and then I've got Bernard's bottom line.
Justice Goodwyn, do you pay attention to who the judge was below? Or?
No, I don't. And I guess it goes back to my analogy about balls and strikes. I mean, if you Rod Carew, sometimes he was out at first, you know? I mean, so I'm just going to look at the facts of the particular case and decide whether or not a mistake was made. It really doesn't matter at all who made the call. And it goes back to, quite honestly, how narrowly we decide things. I mean, I'm just looking at the assignment of error. I'm looking at the record, and I'm trying to see, given the law, whether or not a mistake was made.
Justice Goodwyn, you sort of nodded when we talked about maybe once in a while being surprised.
Being surprised, I guess I was thinking, first of all, it's important to understand that when we have an opinion conference after oral argument, every person on the court speaks to that case. So you know how everybody at that point in time, anyway, thinks the court ought to be resolved, how the case ought to be resolved. And if you're the person writing the opinion, you're writing the opinion, you've told them what you plan to put in it, and that's what should come back. So when the first time we go around the table, a lot of times I don't know what people are going to say. You might have a sense, but you don't. And sometimes people have provocative, not the right word, but you know, the ball bounced at an odd angle. I mean, you know, from what I thought the way it was going to bounce when I hear from them. And really, you just can ask them questions as to, well, why do you think that way? Why do you think it ought to work that way? And a lot of times you're thinking to yourself, well, let's just see what the next person says. And you know, as you work your way around to see whether, you know, it's something that's like a little bit odd or whether you can kind of like miss the boat on what the issue is. And so, yeah, I mean, sometimes the eyebrows go up, but everybody's had a chance to give their input. And the second opinion conference is one where if you have substantive changes, typically it's going to be a bit of a surprise, because the way we operate now is when I circulate my opinion, it's typically going to be at least a week before the opinion conference, and if somebody has a problem, they typically will at least say, you know what, I really have a substantive problem with what you've written, and let me tell you why. And so they're going to typically give you a little bit of a heads up, so it's not so much of the kind of ambush I think they did. I wasn't here back in those days when they did it that way, so I was blessed to have missed that. And I think what happens, honestly, is a lot of times we're going around the table and people agree. If you've got a very complex case with a lot of different issues, sometimes people think, oh yeah, I agree with that, but they didn't agree with the specifics of that. So when you actually put it down on paper, they're like, no, that's not what I meant. And it's kind of like, I said what I said, but I didn't mean it to be what you wrote. And you're saying, aren't they the same? They're like, no, it's not. It's not the same.
Right, it's very different when you put it on paper.
Exactly,
right?
exactly. And that's where the rub comes in at. And that second opinion conference, a lot of times is, a rewrite in order.
So in cases where there's a dissenting opinion, if you were writing the majority, Justice Goodwyn, do you talk to your dissenting colleague through the majority opinion? Do you engage with your dissenting colleague beforehand to try to figure out how each part of the opinion is going to speak to the other part of the opinion? How does that work?
I think it's a matter of personal style. My style is just to pick up the phone and call you. I mean, it's like, what do you, I don't understand. What don't you think is right about this opinion? Is there something I can do to massage it? Can we work it out? And a lot of times you talk through it, and every one of my colleagues are, wonderful people to get along with. And at some point you realize perhaps we just disagree. I mean, okay, well, let's find out where the pinch point is. And sometimes you can smooth it over, and sometimes you can't. And if you can, it's like, okay, I understand you're gonna write a dissent. And typically the dissent is what I expected, given our discussion that we had as to what they disagreed with in the opinion, which, of course, I think they're wrong. so I don't, agree with what they want to say.
So, Justice Goodwyn, what do you think? Is there a Justice Goodwyn style?
I don't think so. I like to think of my style as Spartan, sparse. It's kind of like the Dragnet style, Joe Friday.
Just the facts?
Yep. Just tell it the way it is. Not a whole lot of flash. Just answer the question, which I think is kind of similar to what Lee was saying about the way he writes. I mean, I'm just trying to have something that's accessible, honestly, to everyone. I would hope one could pick it up, follow the logic in it, and see what the answer is.
And Justice Goodwyn, you said you've done that too.
Oh, sure.
Mm-hmm.
And for exactly the same reason.
Mm-hmm.
Or sometimes you want to nail something down, especially if you know a colleague's like, well, I'm not sure about X or Y. It's like, you are saying X, right? You want to make sure that the person articulates it in a way that your colleagues will understand it. So sometimes you might ask them a question to give them the opportunity to do that. And of course, that could cut either way, because I think sometimes you feel like people misunderstand what somebody's saying, and because of that, they would support their position. When in actuality, if you really understand what this person's saying, you would never support that position. And if I have the opportunity in a question to bring that out, especially if I'm hearing questions from my colleagues that are kind of frightening me a little bit about where they're going with the case, yeah, you're gonna ask the question. And quite honestly, through that question, it kind of signals to them your thought process as you go into this opinion conference.
Just sort of rephrase, reframe a little bit.
Exactly,
Yeah.
reframe the issue. And I would also say between the seven of us, typically somebody's going to say, did you really mean to say that?
Mm-hmm.
I mean, somebody's going to probably ask, and that's going to be one of those friendly questions. It's like, just want to make sure you didn't mean to say that you really don't have an appeal, did you?
Right. If they miss that, then they're really not paying attention.
Exactly,
right?
exactly.
Right. Justice Goodwyn, can you talk a little bit about your prior experience and how that's influenced your work?
Sure. I guess having been a trial lawyer, I was a litigator and a partner in a law firm, as well as a year as a law school professor. More than anything else, I recall as a trial lawyer being very frustrated when judges didn't explain what they were doing. And when I became a judge, one of the things I wanted to make sure was that anybody who left my courtroom understood exactly why I had done what I had done. And I feel like that transparency makes just a big difference in people's perception of fairness. As I write opinions now, the most important thing I want people to understand, or the most important thing to me about the opinion, is that people can understand why I did what I did and why I see things the way I see them. And at that point in time, they can look, and I don't mind them saying, well, that was wrong. And as a trial court judge, I always wanted to explain to people exactly what I'd done, and if they wanted to appeal it, that's how I'm gonna get better, right? If it comes up to the Supreme Court and they told me I made a mistake, I know not to do it next time. Whereas I understand some circuit court judges felt like you never explain why you do what you do, because that's how you get reversed. why would you be afraid of being reversed? I never understood that. Aren't you more concerned about getting it right? And if you can't articulate why you're doing it, I always felt like you shouldn't do it. You're not ready to decide the case if you can't explain why you're deciding it. And so I guess that's one of the things I took with me when I came to the bench here.
And was it an easy decision for you?
Or the things you miss?
Which decision?
To take the bench?
Going on the bench? It was something I decided I wanted to do. You know, I practiced law. I was at a firm I loved. I had a great practice. I enjoyed my partners. But I guess I came to the realization that I wasn't very gratified by what I was doing. And I felt like I did not want that to be my life. I wanted to make a contribution in some way to society. And it dawned on me, and a local legislator asked me about being a judge. And honestly, as a young lawyer, I was like, I don't think I'm going out like that, you know? In my mind, it's kind of like, you know, asking Michael Jordan to be an official. I mean, it's like, why would I do that? You know, it just didn't register with me that would be something I would be attracted to do.
All balls and strikes.
Exactly, which I didn't want to do. I wanted to be in the game as a younger person, but once you get a family and you have the demands of law practice upon you, and you think about the other things you want to do in the big picture as far as contributing to society, contributing to the community, and it's hard to fit all of that onto your plate. And I realized that by being a judge, I could do public service as my occupation. It doesn't get a whole lot better than that. And once I sat as a substitute judge, I saw I really liked it. I really liked, you know, not trying to figure out how I can, you know, win the case, but what's the right answer? I'm the guy who gets to sit there and make sure everybody is going to be treated fairly. I was like, it doesn't get much better than that.
So what do you find frustrating about the job? Is there something?
I think what I find frustrating about my present job are the time constraints and trying to do a good job. You know, I guess when I was a circuit court judge, and as a circuit court judge, you have to make calls, I mean, on a regular basis all day long. And I felt like the people in the Supreme Court, you know, they sat there and in my mind they kind of like puffed on pipes and, you know, wore tweed jackets with patches on them and, you know, talked about cases and stuff and got around to eventually writing them. And I got here and I found there are a lot of deadlines and a lot of marks we've got to hit as far as like getting our work done. And so it's a very fast pace. And you've got, in a lot of instances, I would say in a given court week, you know, if we have, it used to be 31, 32 cases, now it's more like in the mid-20s. And there are half dozen of those cases that are really, really hard. They're really, really difficult decisions. You're deciding questions that people have written horn books about. You could spend a month working on one of those cases and still not be sure what the answer is, but you got 6 of them. And you gotta do them all in 6 weeks. So, you know, that whole time pressure of wanting to do a good job and getting everything done is sometimes frustrating.
Justice Powell? Oh, I'm sorry.
And I was just gonna say, because I always feel this way, and in talking to my colleagues, they feel the same way. There's always more you could have done. There's always another case you could have looked at. There's always something else that, you know, you could think about a little bit longer. You think, maybe I could do a little bit better job if I...
One more draft.
Yeah, exactly, but it's like, you know, it's almost like, I keep drawing all these analogies of television shows, but it's kind of like, what is it, the Iron Chef or whatever? It's like, time's up. And, you know, you just have to stop at a certain point, and that's what you have to do with your opinions. At some point, I just got to send it to my colleagues and say, I did the best I could do, and listen to what they have to say.